But sometime today, Malot, because of the urgency.
You want it today only?
Yes. There's clear urgency because the finals is going to be heard. This collusion with these coaching
No, when
centers.
is the next round of examination?
25th.
25th April.
Friday.
That's on
25th
Friday.
is Friday.
And we are already on 22nd.
Tomorrow? Tomorrow morning, first thing?
First case.
Very well. What your lordship can do is perhaps issue notice today and take it tomorrow. So they get a chance to find some reply if they want to.
Learned AC is leading me, my lord, in this matter.
Yes, very well. We will consider that is
Tomorrow.
48, 49, 53
Yes,
matters.
pretty much. Yes.
This
Great.
tomorrow at the top of the list.
Great, sir.
I will.
Basic intelligence. Similarly, note item 47 is also not reflected in sequence. It is also added in supplementary.
No, 47 is pertaining to this Bihar examination.
No, it's a bail matter. It has nothing to do with this 47, 48, 49 and 50.
Some additional documents have to be filed. There was some misprint, etc. in translation. So therefore, Millard, they wanted to file Millard for your lordship saying he.
We will do it. But give a copy to the other side.
Yes, we'll do.
Don't introduce new documents.
No new.
Whatever documents are on record, if you want to replace or if you want to clarify, do that.
Oh,
But don't file documents which are not on record.
okay.
Additional
47
documents confined to replacement of eligible documents to translation of
Clear saying. Yeah, that's me.
47.
What
Please
is
wait, Mr. Deshmukh.
I'll wait, man. No difficulty.
Because,
sequence doesn't include that item. That's why.
No, it's a bill matter.
It's a bail matter. That's why I mentioned it. That's otherwise, Manoj, I'll wait. I'm here for the day. No difficulty at all.
But both 46 and 47 are bail matter. 46 is that GST yesterday's matter. This is coming up for the first time.
No, this is after notice.
All after notice.
47 is after notice. It was added in supplementary. So, Manoj,
Actually, the difficulty is, special benches are constituted. We are
I
not
understand,
kept in
but
the
now
loop.
what's looking-
And it is not taken.
I know that Millard's lordship, which is only requesting one of the matters, 90, pertains to home buyers. 400, more than
We'll
400.
consider. We'll consider. Not in this way. Yes, column number 1.
There is only one application, Millard's.
We will consider. Yes, item 1.
That's for the response.
There are many issues for us.
Thank you, Mr. Nagamoto. We have valued that judgment in the probation matter.
Section 4.
Section 4. You said that D60 has been made mandatory, not 4 of the POI. We have made it mandatory.
The most of confusion remains us.
Here,
In this matter, there are
protest petition dismissed.
There are some legal issues which may require consideration by this honorable court. I am ready now to go ahead with the case. This is a case of murder. But originally, Maharaj, the FIR was registered in crime book 54 of 2017 on 25/5/2017, where 8 accused were shown. 8 accused. Well, the issue is very simple. 8 accused. The accused for 7 and 8 murder are the daughters of the first accused. 7 murder was a medical student doing MBBS. 8 murder was doing agriculture. During the period, they have students here, girls. But they were also included as accused to 7 and 8 murder in the FIR. During investigation, the family members of the deceased murder repeated the same allegations and said that they were also present and they were orally they said something, etc. The investigating officer examined people who are residing in and around the area who are also eyewitnesses. They have said in unison that these two were not at all present there. Based on the statements of those independent witnesses, numbering about 7 or 8, the investigating officer dropped these 3 people, namely the wife and 2 daughters, and filed a charge sheet before the court. The court now after Bhagan Singh Murad issued a notice, of course, Murad to the defective complainant. Defective complainant Murad filed a protest petition. Murad, the protest petition will appreciate Murad. If it is a simple protest petition, Murad, it will be an endeavor to convince the court to take cognizance, Murad, as against these people also and issue summons to them. If it is a simple protest petition. If it is so filed Murad by way of protest petition, the court may either accept it or reject it. That's the only course available for the court. Or the court may even order for further investigation. The other option is not to treat the protest petition as a private complaint and to proceed for provided the protest petition is in the form of a complaint as defined in this court. Namely, the witness list, document, etc. Everything should be there. But in this case, the court was a little confused. The random magistrate was a little confused. He treated the same as a protest petition, not as a private complaint. To treat the same as a private complaint, there has to be a judicial order saying that I am treating the same as a private complaint and I am calling upon the witness, prosecution to produce a witness under 200-202. But there is no such order. The London magistrate not straight away not allowed the complainant to examine the witnesses under 202 without taking cognizance. But section 200-202 could come into play only after taking cognizance by treating the protest petition as a private complaint. It was not done. Straight away, these witnesses were examined. Finally, the London magistrate was convinced that there is no material against these three ladies, and therefore the London magistrate dismissed that petition as a protest petition still, not as a private complaint. He dismissed it. Again, that the complainant filed a revision before the Honorable High Court. But the Honorable High Court allowed the petition.
No, did he treat it as a private complaint or did he dismiss it ultimately?
He dismissed it.
But after treating it as a private complaint?
No order, treating the same as a private complaint. But witness were examined at 202, dismissed as a private, not as a private complaint, as a protest petition. Again.
So he was only treating it as a protest petition. He never treated it as a private
If
complaint.
that is the case, not examining witness won't arise under 202. 202 will come only after 200.
We have conducted sort of a mini trial at the stage of considering this, that LW1 did not say this, he did not do that. What is this? Paragraph 5 onwards, Mr. Nagar.
I am only pointing out
This course of action should not have been adopted by the magistrate. The
magistrate.
primacy appears to be right.
I'm not supporting order of the magistrate. The magistrate should have dismissed it as a private complaint under 203. In which case, that order could have been challenged.
But he's not treating it as a private complaint. That's what we find.
Then how can we examine?
But just tell us, where has he treated it as a private complaint? He would have passed an order saying, I'm treating it as a private complaint, you step into the box. That formal order would be required. Otherwise, how would the complainant also know that he has to step into the box and read everything?
No formal order is required, number one. Number two, witnesses can be examined only thereafter. And if the court takes cognizance, it will be under 191 1A on the private